Thank you very much for such nice introduction, and of course for the invitation. It is my pleasure to be here. So what I'm going to present today is some findings from my PhD research. It is not exactly the newest stuff, but since I was looking at the question on which safeguards should be implemented in the notice and action, based on the E-Commerce Directive to ensure compliance with the right to freedom of expression, and whether, sorry, just moving some stuff around, and whether the requirement to introduce such safeguards could be based on the theory of positive obligations. So it seems that, it's still relevant for the ongoing discussions on the DSA proposal. All right, so I'll start with a quick trip down the memory lane. Article 14 of the E-Commerce Directive contains conditional liability exemptions for hosting providers for the content of their users. So hosting service providers can benefit from a liability exemption if they don't have actual knowledge of illegal activity, and as regards claims for damages, are not aware of facts or circumstances from which this illegality is apparent. And upon obtaining such knowledge or awareness, they expeditiously remove or disable access to the information. The provider of a hosting service can obtain such knowledge through a notification by a private party, among other options, asking to remove or block access to the content. The mechanism is commonly referred to as notice and takedown. So the directive laid a groundwork for notice and takedown, but it did not provide any additional guidelines with regard to its implementation. But instead, it left it for the member states to specify. And some of the member states indeed developed more detailed formal notice and takedown procedures, but majority of them did not do it. As a result, there is a lack of any firm safeguards for content removal procedures in most of EU countries. So a decision about the speech online is in a way left to private entities. And while such delegation of powers may be considered an efficient and effective method to tackle illegal content online, it obviously raises several concerns. So state tasks are delegated to entities that are not competent to make this type of decisions. There's no proper balancing of rights at stake. It may lead to over removal of legal content because hosts have a compelling reason to remove, but not really equally compelling reason to keep content online. So it could affect fundamental rights of internet users, and in particular lead to undue restrictions to speech through private censorship. And because it is incentivized by the legislation, I called it a type of state interference by proxy. But even when delegating obligations to private bodies, the state retains certain responsibilities to protect fundamental rights. And according to human rights instruments, such as the Convention and the Charter of Fundamental Rights, states should not interfere with the exercise of protected rights unless there are specific conditions that are met, but also they have an obligation to effectively protect fundamental rights from interference also by other private individuals or other private parties. And as I argued, it is even more so if such interference is encouraged by the state. So in the convention, the concept of positive obligation is based on Article 1, which requires that states shall secure to everyone the rights and freedoms defined in the convention. There's no authoritative definition of positive obligation, but the concept is described as a requirement to take action, an obligation to protect, or an obligation to implement to ensure that the protection is practical and effective. And as the court stated in Ding versus Turkey, states are required to create a favorable environment for participation in public debate for everyone. What else? Positive obligations exist even if the state outsources regulation, for example, to alternative regulatory bodies. as a court held in Costello-Roberts versus the UK, the state cannot absolve itself from responsibility by delegating obligations to private bodies or individuals. But Article 10 does not actually create any freedom of form for exercise of the right to freedom of expression. So that the positive obligation in the context of Article 10 should not be understood as a type of must-carry obligation for all types of content that is not illegal. Okay, but the convention applies only to the signatory countries of the convention, and the E-Commerce Directive is an instrument of the European Union. And since the EU is not a signatory, or at least not yet signatory to the convention, we actually have to look at the charter. So under the charter, the negative obligation, so obligation to respect, is clearly articulated. The existence of the positive obligation is less obvious. And according to Article 51, paragraph 1, rights in the charter must be respected, principles observed, and both have to be promoted. But what does it actually mean? Some useful guidance can be found in the case law of the Court of Justice. So in Coty, Germany, the court stated that the right to obtain information about those behind the trademark infringement aims to ensure effective exercise of the fundamental right to property. In Digital Rights Ireland, the court declared that Data Retention Directive did not provide for sufficient safeguards to ensure effective protection of the data retained against the risk of abuse. And as a result, the directive was invalidated. In the 2015 Schrems decision, the court repeated the arguments that EU legislation involving interference with fundamental rights must lay down clear and precise rules governing its scope and application of measures, and impose minimum safeguards to effectively protect the rights against the risk of abuse. So it's true that in these cases, the Court of Justice did not refer explicitly to positive obligations, but pointed out the lack of effective protection, which should have been ensured by providing sufficient safeguards. So based on these findings, I argued, and I still do, there exists a positive obligation to protect also under the charter. And that even without explicit reference to the doctrine of positive obligation, the CJU is able to achieve a similar result by using the principles of proportionality, the requirements of fair balancing, and effective protection. And also that there is a problem with the E-Commerce Directive, which does not comply with such an obligation to effectively protect. Sorry. One way to ensure such safeguards or such effective protection in the context of notice and action mechanism would be that the delegation of censoring powers must be equipped with certain protective measures that would put some limits on how this power is exercised. And that could take a form of adequate safeguards, both substantive and procedural. And in my research, I proposed a number of such safeguards grouped by categories. So these safeguards should aim to improve, first of all, the quality of law by ensuring that legal framework delegating the power to restrict speech is accessible, foreseeable, and predictable. And here the examples would be clear and predictable rules at EU level containing safeguards, both substantive and procedural, preferably in a form of regulation to avoid fragmentation across member states. I also argued that distinction between active and passive hosts, which is actually not in the E-Commerce Directive, but resulted from a judgment of the Court of Justice, should be eliminated, and that focus should be on knowledge and control of illegal content. And the main reason here is that clarifying that broad scope of the exemption would be beneficial for the right to freedom of expression. Because with the new types of online services that do not necessarily fit in the old definitions of the directive, they may be taking more cautionary approach, as it's not clear whether they could benefit from the liability exemption for third-party content. Then safeguards to ensure that measures interfering with online expression are proportionate and impose minimum impairment of the rights to freedom of expression. And here, that a selection of appropriate response mechanisms should be possible and not only a takedown as a unique response, right? So going more for notice and action and not just notice and takedown. Also, safeguards in the area of procedural fairness, which focus mainly on the way how decisions are taken. And the main goal here was to bring in an element of due process. So examples are a notification to the content provider that it would inform them that a complaint has been filed against the content, and also about the nature of this objection. And also counter notice mechanisms that would allow content provider to defend their use of content, and by this operationalize the rights to fair hearing, to adversarial proceedings, and to equality of arms. And ideally that would happen before action against content is taken. Safeguards to ensure effective remedy, because decisions about content are not easy to make and mistakes may happen, do happen, but there should be a way to rectify it and ensure that appropriate relief is possible. So here, a possibility to appeal a decision at the intermediary level through clearly defined procedure that would allow for bringing the content back, but also judicial redress. And finally, safeguards to ensure more transparency, to gather data on the functioning of these mechanisms and safeguards through transparency reports by platforms, but also reports by states, because only such combined reports could actually give us a full picture on how this mechanism is functioning, which is necessary for evidence-based policymaking. And so now I'll look at some safeguards that are contained in the DSA. And just to be clear, it's not an exhaustive analysis. I looked at the selection of safeguards that correspond to what I proposed, but you probably could analyze every provision there to see if it actually safeguards or endangers freedom of expression. So first, in the area of quality of law. So the DSA has a form of a regulation which allows to mitigate the problem of fragmentation. It also clearly states that one of these goals is to ensure more protection for fundamental rights, and in particular, freedom of expression. Okay, so far so good. But what about safeguards aimed to improve clarity and foreseeability of the rules? So first, the DSA builds on the E-Commerce Directive. So the proposal reproduces the old articles 12 to 15 and provides some additional clarification. And while this is good from the perspective of continuity, but it also maybe has a potential to replicate some of the previous weaknesses of the directive. So first of all, the distinction between active and passive hosting is still very much alive. Recital 18 specifically says that liability exemptions should not apply when the provider plays an active role of such a kind as to give it knowledge or control over the information. That codifies the earlier interpretations as well as the CJEU rulings in Google France and L'Oréal eBay that providing active services may lead to the loss of immunity. The DSA also does not clarify the difference between actual and constructive knowledge, which was something that was criticized already in the directive. Article 14 of the DSA lists necessary elements of a valid notice, and I think that that's good. And some of these elements include explanation of reasons why content is considered illegal, what is its exact electronic location, and others. But it seems to suggest, Article 14, that the mere presence of these elements give rise to actual knowledge or awareness. From what I understood from several presentations by the members of the Commission, that was not the intention, and that a valid notice would still have to be sufficiently precise and adequately substantiated, which is the wording from the L'Oréal eBay, I think. And that notice would still have to be examined to determine the illegality of content in question. But as it is phrased right now, Article 14, paragraph 3, for me, could be read as automatically leading to knowledge. And it still doesn't really make that distinction between actual knowledge and awareness, and does not require court order to create actual knowledge, which is something that some stakeholders advocated for. And then we have a new element in the DSA, a provision on voluntary own initiative investigations by hosting providers in Article 6. This provision basically encourages hosting providers to take on voluntary measures to detect, identify, remove, disable of access to illegal content. And interestingly, Recital 25 explains that the mere fact that providers undertake such activities does not lead to unavailability of the exemption of liability. If those actions are undertaken in good faith and in a diligent manner. And this applies to activities taken to comply with the EU law, but also as regards implementations of their own terms and conditions. So for me, this provision attempts to incentivize hosting providers to take more initiative against illegal content, but also content violating their own terms and conditions without an immediate risk of losing immunity by being considered active. It also furthers policymakers' goal to have intermediaries do more to police content without violating the prohibition of general monitoring obligation. But from the perspective of users and the right to freedom of expression, I would say it's questionable whether facilitating more voluntary removals is actually beneficial. Then safeguards on procedural fairness. So we have Article 14 again that lists information to be provided to the notifier, a confirmation of receipt of a notification, and also notification of a decision listing possible redress options, which I think is good. Information to be provided to the content provider is specified in Article 15. So where the host decides to remove or disable access to specific content, it should inform the recipient or the user of this decision at the latest at the time of the removal or disabling of access. It should also provide clear and specific statement of reasons for that decision. And Article 15 lists also what information should be included in that notification. If it concerns removal or blocking, facts and circumstances leading to that decision, if the decision was made using automated means, legal or contractual grounds, and information on redress possibilities. So the provision says that the notification should be sent at the latest at the time of the removal or disabling of access. But it doesn't really leave much room to wait for a response and to take it into account when making the decision. So for me, these provisions don't really introduce a counter notification mechanism, only a complaint that is possible later on through an appeal mechanism. And then in the area of effective remedy, the DSA provides actually several options. First, we have the internal appeal mechanism or a complaint handling system in Article 17, which specified that the mechanism should be available for at least 6 months following a removal decision or a decision to suspend or terminate the service or a user's account. And that refers to both situations when content was deemed illegal, but also incompatible with terms and conditions. And the provision does not specify exactly what elements should be included in the complaint, but it does say that if a complaint contains sufficient grounds showing that information is not illegal or not incompatible with terms and conditions, it should be reversed without undue delay. And what's interesting is that Article 17 only talks about complaints in case of removal, blocking, or suspending decisions, but it does not mention the possibility to appeal a decision where an initial notice, for example, under Article 14, was rejected. So even though that might sound a bit counterintuitive from the perspective of freedom of expression, I think we have enough examples of when a notification on online abuse or harassment is rejected, and as a result, that leads to chilling effect and suppression of minority voices or underrepresented speakers. So for me, that that's maybe something that could be added there, especially that in Article 14, the decision on the notification includes possible redress mechanisms. On the out-of-court dispute settlement, that I'm not sure if I'm the best person to talk about it. I didn't really do much thinking about it. It is a bit of a novel idea, and although interesting, I feel like there might be many unknowns. So I would probably repeat Daphne Keller's suggestion that she made yesterday, that maybe at least at the beginning that could be limited only to very large platforms. And finally, judicial redress doesn't really have its own provision, but it is mentioned on several occasions as one of the redress possibilities, which the users have to be informed about. As for transparency, there are several provisions on that, applicable depending on the type of intermediary. So we have transparency reporting addressed in Article 13, 23, 33, but also database of decisions managed by the Commission in Article 15. There's also provision on access to data by vetted researchers, which is something that was long requested for. There's also, Article 44 on the activity reports by the digital service coordinators that would have to include information on the number of orders against illegal content and orders to provide information. So what is in Article 8 and 9 of the DSA. So that looks promising. And I'm not going to be the first one to say that, transparency resulting from these provisions must be meaningful to actually, provide what it's supposed to provide and give us a picture of the situation and possibly ensure some form of accountability. And to end, I would just like to add that in general, I consider DSA as a good starting point, good proposal, and I'm glad there is a number of safeguards there. It doesn't really address some of the concerns that were really already expressed about the E-Commerce Directive. It repeats the same approach. So I think there is definitely a room for improvement.